Hello, and welcome to Understanding Your Responsibilities as a Housing Provider under federal, state, and local fair housing laws. Today we'll be covering the following topics: the Fair Housing Act, the federal anti-discrimination law that covers housing, the guidance from the U.S. Department of Housing and Urban Development, which is also called HUD, on criminal background screening policies, the Minnesota Human Rights Act, the state law that protects residents against discrimination in housing, and the City of Faribault's revised rental licensing ordinance. Related to the ordinance, we'll be discussing the limited criminal screening and individualized assessment process, record-keeping requirements, what constitutes disorderly conduct, crime-free, drug-free lease addendum, appeal rights for tenants and licensees, preventing the eviction of survivors of domestic violence, occupancy standards, and certification, as well as penalties for violation. Before we get started, I want you to think back to the last time that you or your family were looking for a home to rent or to buy. What are some of the things that you were looking for? The answers that we frequently hear include a certain number of bedrooms and bathrooms, specific amenities or features like a big yard, being close to work, being close to school or in a particular school district, near grocery stores, shopping centers, restaurants, bars, or retail stores, not too much traffic, somewhere where you feel safe, not in a flood zone or near other environmental hazards, near public transportation, near parks or other recreational opportunities. When someone discriminates against you in housing, it doesn't just take away that particular home you were hoping to buy or that apartment that you were hoping to rent. It takes away all of the things that you would have been able to access if you lived there. It could mean that your children aren't able to go to good schools, that you have fewer job opportunities, that you don't feel safe at home or going for a walk in the evening, that it's more expensive to live there than other options, and that you're not able to save money or build equity for your family. It could mean that you don't have access to transportation or healthy food or recreational opportunities, and on and on and on. When we have discrimination and inequality in our housing system, it feeds inequality in other areas, including in education, employment, and health outcomes. That's why it's so important that we work for fair housing in our communities. The Federal Fair Housing Act was signed into law on April 11, 1968, exactly 1 week after Dr. Martin Luther King Jr. was assassinated. It was one of the most important achievements of the civil rights movement. Until it was signed, housing discrimination was legal and encouraged by government policies at the local, state, and federal levels. In fact, the federal government itself used a tool called redlining to prevent people of color from purchasing homes in predominantly white neighborhoods. Housing segregation was also supported by industry practices and by neighborhood organizations and individual homeowners. You may be wondering if all of this is a problem in the past. Unfortunately, it is not. Nationally, housing segregation is worse today than it was in 1990. A recent report from the Federal Reserve Bank of Minneapolis found that the gap between the homeownership rate in Minnesota for white households and households of color is the 4th largest in the nation. And for Black Minnesotans, this gap is increasing. The Fair Housing Act outlaws discrimination in housing based on 7 categories, often called protected classes. Those are race, color, religion, national origin. This category protects people from discrimination based on where they, their parents, their grandparents, or anyone in their ancestry are from. It also protects people from discrimination on the basis of languages that they speak. Sex. This category includes protection from discrimination based on sexual orientation or gender identity, and it prohibits sexual harassment in housing. Familial status. This category protects people who are pregnant or have children under 18. Children under 18 includes biological children, adopted children, foster children, or children that they are in the process of gaining custody of. No one can be discriminated against because they're pregnant or because they have children. disability. Today, more than half of all fair housing complaints have to do with disability discrimination. Disability functions a little bit differently from other protected classes. People with disabilities, just like any other protected class, are protected against discrimination. Additionally, sometimes people with disabilities may need to be treated differently to be treated fairly, and the law allows for that. If someone has a disability, they're entitled to reasonable accommodations, which are changes to a policy or a rule. For example, a no pets policy or a breed restriction or size restriction may have to be waived if an individual needs an assistance animal, like a service or emotional support animal. The law also allows people with disabilities to make physical modifications to their homes. Some examples include installing a ramp for wheelchair or walker accessibility, lowering counter heights, lowering light switches, installing grab bars in the bathroom, or installing a doorbell that flashes a light instead of making a sound for tenants who are deaf. All of those are examples of reasonable modifications. As long as a modification or accommodation request is both reasonable and necessary, generally it must be allowed. Disability under the Fair Housing Act is defined pretty broadly. It's any kind of physical, mental, or emotional condition that substantially limits one or more major life activities. That includes things you might think about, like being blind, deaf, or hard of hearing, or being in a wheelchair. Additionally, disability can include things like cancer, diabetes, heart disease, asthma, post-traumatic stress disorder, depression, anxiety, bipolar disorder, schizophrenia, being HIV positive, alcoholism, or a history of illegal substance use and addiction. The Fair Housing Act does not protect current use of illegal substances, but if a prospective tenant has a record of addiction, they can't be discriminated against because of it. More recently, long COVID has increasingly been recognized as a disability. I talked about who is covered by the Fair Housing Act. Now I'd like to review where and when it applies. The Fair Housing Act applies to almost any type of housing you can think of, including apartments, condos, single-family homes, doubles, triples, mobile homes, group homes, dormitories, nursing homes, and in many cases, homeless shelters. The Fair Housing Act even covers land that's going to be developed for housing, even if it hasn't yet been developed. In fact, any land use decisions must follow the Fair Housing Act. The Fair Housing Act applies to pretty much any housing transaction you can think of. This includes the process of renting a home, living in a rental property, purchasing a home, applying for an insurance policy or mortgage, and advertising housing vacancies. It also applies to zoning decisions, which are when a local government makes a decision about land use and housing locations. The Fair Housing Act protects people from harassment based on their protected class status and safeguards them from retaliation. Under the Fair Housing Act, retaliation is illegal, regardless of whether the original complaint is found to have merit. So, for example, if a tenant files a fair housing complaint against their landlord, alleging racial discrimination, and the complaint is investigated and there's no evidence of discrimination found, if that landlord then evicts the tenant because the tenant filed the initial complaint, the landlord has violated the Fair Housing Act by retaliating against someone for exercising their fair housing rights. Now we'll talk briefly about how the Fair Housing Act applies to rental transactions. It's illegal to advertise a preference for a tenant or buyer based on membership in any of the protected classes. Advertising can include many different types of communications, including online ads on sites like Zillow or Realtor.com, signs in the front yard or window, advertisements in the newspaper and social media. It also includes utterances, which are verbal comments about available housing units. You want to make sure that your advertisements describe the amenities of the home and of the neighborhood. Your advertisement should not be about the people the housing provider thinks should live there, nor about people that already live in the community. If you choose to use images in your advertisements, make sure that they're inclusive. If you do any sort of targeting of your advertisements, for example, on Facebook or another platform, ensure that the targeting that you're doing does not exclude any protected classes. During the application process and screening procedures, every single applicant must be fairly considered, and every single applicant must be treated the same when they inquire about vacancies. Each applicant must be told about the same options, evaluated using the same criteria, and receive the same amount of follow-up as any other applicant. Steering is one way we frequently see discrimination happen during the application process. Applicants might be steered or directed to areas where other residents are of the same race or national origin. For example, when an applicant requests to look at an apartment, the housing provider may only show the applicant properties in one neighborhood instead of showing the applicant the full range of options. Steering can also happen if a landlord only shows first-floor units to families with children, even if there are second-floor apartments available. Similarly, steering can occur if a landlord only shows a person with disabilities units on the ground floor, with the assumption that it would be too difficult for the applicant to live on the second floor. In these examples, the landlord should not make those decisions for the applicant. It's up to the family with children or the person with disabilities to determine which options work best for them. Not returning calls, scheduling showings, or following up with applicants in a timely manner can all be warning signs of discrimination. You want to make sure that you conduct your business fairly and equitably for all applicants. Everyone should get a call back. Everyone should be able to schedule a showing. Everyone should get an equal amount of follow-up, and everyone should be told accurate information about all available units. Do not have different requirements, terms, or conditions for different applicants. For example, do not tell one applicant that they have to have a certain credit score while telling another applicant, oh, the credit check is just a formality. If you have specific requirements and screening criteria, they must be applied fairly to all applicants. Discretionary policies applied differently based on protected class can also violate the Fair Housing Act. Examples include criminal background screenings applied more leniently to some applicants than others, or financial incentives for some applicants that are not offered to others. Incentives such as move-in specials, $50 off the first month's rent, waiving an application fee, or allowing tenants to pay the deposit over several months are fine, but they must be offered equally to all applicants. Another way that the Fair Housing Act applies to rental transactions is through maintenance and resident relations. Housing providers must be careful to make sure that all residents are treated the same, regardless of their protected class status, unless, of course, they're a person with a disability who has requested a reasonable accommodation or modification. That means that if, for example, there are particular amenities in the home, like a common area, pool, or laundry facility, all residents should have equal access to those amenities. Additionally, all rules for residents must apply fairly and reasonably. For example, if there have been problems with toys left out on the sidewalk, it would not be appropriate to post a sign that says, "Children may not leave toys in common areas." That particular policy, though it may be designed to address a specific problem, could violate the Fair Housing Act because it singles out members of a protected class. A less discriminatory alternative could read, "Residents may not leave personal items in common areas." That policy does not only apply to a protected class, it applies to everyone. However, just because there's neutral language in a policy does not mean you're complying with the Fair Housing Act. The policy must be enforced equally among all tenants. So if you have a policy that has neutral language, like the one in this example, but only the families with children are getting in trouble for violating that policy, there could still be a fair housing violation. Lastly, harassment is illegal under the Fair Housing Act if it's based on membership in a protected class, and if it's pervasive enough to create a hostile environment. Harassment can include hate-related activity in or near the home, like vandalism or threatening notes, verbal harassment, like the use of racial epithets, or physical intimidation. Quid pro quo sexual harassment is also a violation of the Fair Housing Act. This is when someone is singled out based on their sex, and a housing provider tries to get them to exchange sexual acts for housing services, such as reduced rent or repairs in the unit. Harassment can violate the Fair Housing Act whether the perpetrator is a landlord, a property manager, a maintenance worker, or even another tenant. For example, if a maintenance worker is harassing tenants, the landlord can be held liable for that behavior. A landlord who knows that tenants are harassing other tenants but doesn't act to address the situation can also be held liable. Actions taken by the housing provider to stop the harassment cannot include any sort of penalty for the person who brought forward the allegation. An important aspect of the Fair Housing Act is that policies that have an unfair impact or effect on a protected group can be illegal even if there's no intent to discriminate. An example of this is illustrated by HUD's guidance on the use of criminal backgrounds. HUD is the U.S. Department of Housing and Urban Development. It plays a key role in enforcing the Fair Housing Act. The guidance makes clear that any policy that is overly broad, meaning that it screens out anyone who has a criminal background without considering the specific applicant or their individual history, can be found to violate the Fair Housing Act. As many as 100 million adults in the United States, or nearly 1/3 of the population, have a criminal record. Across the United States, Black and Latino people are arrested, convicted, and incarcerated at rates disproportionate to their presence in the general population. Consequently, policies that screen out people with criminal records will especially hurt home seekers who are people of color. So what does an overly broad criminal background screening policy look like? If a policy screens out someone simply because of an arrest, even if they were not convicted, that policy, even if applied to every applicant, will violate the Fair Housing Act. It will especially hurt Black and Latino renters and cannot be justified. Also, if a criminal background screening policy doesn't take into consideration individualized factors, such as the seriousness of the offense, the time since the offense occurred, if someone has participated in rehabilitation programs, among other factors, then the policy could likely violate the Fair Housing Act. This finding is independent of whether the housing provider intended to discriminate based on race or national origin, and whether that policy is equally applied to all applicants. In just a few minutes, we'll go into more detail about how the City of Faribault's rental ordinance applies to criminal background screening policies to help licensees comply with federal law. Before we wrap up the section on the Fair Housing Act, I want to mention that when it comes to fair housing liability, a housing provider is liable for both their own conduct as well as their failure to take prompt action to correct and end a discriminatory housing practice conducted by their employee or agent when they know or should have known about the discriminatory conduct. Take a situation where a maintenance worker is harassing a tenant. If the housing provider either knew or should have known about the harassment taking place and didn't take any action to stop the harassment, then they can also be liable under the Fair Housing Act. There's also the potential for vicarious liability, which means that someone in authority can be held liable for a fair housing violation, even if they did not know that it was happening, because they've created an environment where discrimination was tolerated, where there were no policies or training in place to prevent it, and where there was no accountability mechanism in place to address this behavior. Now that we've wrapped up the section on the Federal Fair Housing Act, we're going to talk briefly about the Minnesota Human Rights Act, which is the state fair housing law. It's largely equivalent to the Federal Fair Housing Act, but there's one important difference. In addition to the 7 protected classes under the Federal Fair Housing Act, again, those are race, color, religion, national origin, sex, disability, and familial status, there are additional protected classes in Minnesota law, including creed, marital status, and public assistance status, like the use of a housing choice or Section 8 voucher. In Minnesota, a housing provider may not treat an applicant who uses a voucher differently from an applicant who's paying the rent using waged income. Like the Fair Housing Act, the Minnesota Human Rights Act also outlaws discrimination in rentals, sales, advertising, lending, and insurance, as well as harassment and retaliation. The Act also outlaws blockbusting, which is a practice of using fears about racial demographic change to pressure residents to sell or leave their homes. We've talked about both federal and state law. Now I want to focus specifically on the responsibilities of housing providers in Faribault, Minnesota, under the revised rental ordinance. Chapter 7 in the City Code was changed in 2022. Now, under the revised rental ordinance, housing providers must certify that they're in compliance with the new ordinance every time they renew their license. Criminal background checks are now optional for all housing providers, though they're still recommended by the city. This is a significant change from the last several years, so I'll just reiterate that licensees in Faribault are no longer required to conduct a criminal background screen of prospective tenants. If you do choose to conduct a criminal background check, any criminal background check you perform must follow a two-step process to ensure that applicants are not unfairly excluded from housing due to prior involvement in the criminal legal system, which does not indicate a demonstrable risk to resident safety and/or to the property. The licensee certification requirement requires that you swear under penalty of perjury that, number one, you, the licensee, understand that you are not required to conduct criminal background checks on prospective tenants. And if you choose to do so, you must do so in compliance with the revised two-step policy. Number two, you, the licensee, completed this training video to make sure that you understand your responsibilities under federal, state, and local law. And then number three, you, the licensee, maintain adequate records of rental housing applications for at least 3 years to the extent allowed by state and federal law. Licensees who choose to use a criminal screening policy must also provide a written copy of the two-step criminal background check policy provided by the city to every applicant prior to accepting the application fee. This requirement ensures that applicants are notified of their rights. It is available on the City of Faribault's website. Now I'm going to talk about the limitation on criminal screening. If you choose to conduct it, and the two-step process that must be followed. Step 1. The ordinance limits what portions of a criminal record may be considered in a housing application. When conducting a criminal background screening, housing providers can only consider felony convictions within 5 years of the rental application, and only if they fall within the following categories. Number 1, property offenses. Number 2, fraud offenses. Number 3, major violent offenses against person. Number 4, sex offenses. A conviction that meets the specifications is considered a covered criminal conviction, and those are the only situations where you may consider a criminal background in screening applicants. You may not consider a criminal background if that screening is done on children, anyone under the age of 18. You cannot consider any felony convictions within the last 5 years unless they are a covered criminal conviction from that list of 4 types of offenses. You may not consider felonies from more than 5 years ago, regardless of the category of the offense. Misdemeanors from any time at all cannot be considered, regardless of the category of offense. Arrests from any time cannot be considered, regardless of the category of offense. Lastly, tenants may challenge the accuracy of their criminal record. So here's a summary. Can you consider a result of a criminal background screen on someone under the age of 18? No, you may not. Can you consider a felony conviction from more than 5 years ago? No, you may not. Can you consider a misdemeanor conviction? No. An arrest record? No. A felony conviction from within the last 5 years for a property offense? Yes. A felony conviction from within the last 5 years for a fraud offense? Yes. A felony conviction from within the last 5 years for a major violent offense against persons? Yes. And a felony conviction from within the last 5 years for a sex offense? Yes. Now let's discuss step 2, the individualized assessment. If you do conduct a criminal background check that shows that they've been convicted of one or more felonies in the covered categories in the last 5 years, you must then conduct an individualized assessment of that application. You may not automatically deny that applicant housing based on their criminal record. The purpose of an individualized assessment is to assess whether that individual could be a good tenant despite their record. Let's discuss the procedure for conducting an individualized assessment. First, you must inform the applicant using the additional information request letter. A template is available on the City of Faribault's webpage, and it follows on the next 2 slides. This letter will inform the applicant that covered criminal conduct was identified in the limited criminal background screening and will invite the applicant to provide additional information for the housing provider to consider during the individualized assessment. The template letter has a place for you to list out the convictions that showed up on the criminal background screening, as well as the service provider who conducted the criminal background screening. The letter invites the applicant to contact the service provider if they believe the information to be incorrect. The letter also invites the applicant to provide documentation to you, the licensee, if necessary, to establish that an expunged conviction, a conviction that was overturned on appeal, or a sealed juvenile record erroneously appeared. If any of those apply, you cannot consider that information. If the criminal background is not in error, the applicant should be invited to submit information about the following factors: the facts and circumstances surrounding the criminal conduct, their age at the time of the crime, evidence of good tenant and employment history, evidence of rehabilitation efforts, the time that has elapsed since the conduct, any information about the applicant that indicates good conduct since the events occurred, whether that conviction arose from the applicant's status as a survivor of domestic violence, sexual assault, stalking, or dating violence, or because of a disability, such as mental illness, any other factors related to whether the applicant's specific criminal history poses a threat to the safety and security of your residents, associates, and the property. You'll let the applicant know that if they have to send information back to you within 7 days after the receipt of the letter. Again, there's a list of all the different kinds of evidence that applicants should be invited to provide. If the applicant does not submit any additional documentation, then you should conduct the assessment based on the information that you already have. Now we're at step 2 of the individualized assessment. Again, the applicant has 7 days after receipt of the letter. If they don't provide any additional information, you can do the assessment using all of the information you have from the criminal background screening provider. If they do provide additional information, you must use all information provided to determine whether the applicant would be a good tenant. Unless they pose a real, substantial risk to the property or to the personal safety of other tenants, their application should be approved. Again, here are the factors that you are required to consider when conducting an individualized assessment: the facts and circumstances surrounding the conduct, the prospective tenant's age at the time of the conduct, evidence of good tenant and employment histories or rehabilitation, how long it has been since the events occurred, any information that indicates good conduct since the events occurred, whether that conviction arose from the applicant's status as a survivor of domestic violence, sexual assault, stalking, or dating violence, or because of a disability such as mental illness, and any other factors related to whether that prospective tenant's specific criminal history poses a threat to either the residents or the property. If, after the individualized assessment, you decide to rent to an applicant, you will let them know. On the other hand, if, after the individualized assessment, you decide to reject an applicant, then that same day, you must provide a criminal background adverse action letter using a template provided by the city. The template is here on the following 2 slides. In the letter, you're required to note the credit screening provider and the information that was provided to you from them, the criminal background screening provider and the information that was provided to you from them, and any additional materials that you receive from the applicant. The template letter lists out the types of offenses that are considered covered criminal conviction so that the applicant can review that information. Then you will notify the applicant that after the individualized review, they have not been accepted to rent at your property. Lastly, the letter concludes with a notice of rights to the applicant, including that they have a right to challenge the information on record with their credit report by contacting the agency that has provided that report. So that's a summary of a limited criminal background screening process, including the individualized assessment. Next, we'll discuss the record-keeping requirement. Licensees must keep records of all individualized assessments for at least 3 years after the receipt of each application, to the extent allowed by state and federal law. Those records are subject to inspection by the city. Records should include all rental applications, the criminal records associated with those applications, letters between the landlord and the applicant, the ultimate rental decision for that applicant, and the basis for that decision. If there is a reasonable basis to believe that a licensee is violating the ordinance, for example, if an applicant complains, the city can investigate, which may include sharing records with a third party and taking appropriate action. Now I will briefly cover the new crime-free, drug-free lease addendum. All agents, owners, and property managers of rental dwellings in the city must, number 1, attend a certified crime-free housing course, which includes a fair housing component. Number 2, use a written lease, which includes the crime-free, drug-free housing lease addendum included below. And number 3, actively pursue the eviction of tenants who violate the terms of the lease and/or the crime-free, drug-free lease addendum. Please note that going forward, the existing lease addendum is obsolete and must be replaced by the new lease addendum. Only acts of violence or drug-related illegal activity qualify as violations of the addendum, and only if they occur in the dwelling or common area. There are many limitations as to what qualifies. Make sure you understand which offenses qualify as violations. You can review the crime-free, drug-free lease addendum, which is included on the slide below. The addendum states that tenants, members of the household, and guests shall not engage in any drug-related activity on the premises or acts of violence. If there is a violation, that violation shall be a violation of the lease and cause for termination. Acts of violence include behavior involving physical force intended to hurt, damage, or kill another being. It's important to understand that not all offenses violate the crime-free, drug-free lease addendum. Likewise, not all offenses qualify as disorderly conduct. Disorderly conduct is prohibited in all licensed rental dwellings. It's the responsibility of the licensee to prevent disorderly conduct by tenants, their family members, or guests in the rental dwelling. Please keep in mind the ordinance prohibits disorderly conduct in the unit, which the tenant, family member, or guests occupy, along with the common areas both inside and outside of the building where the rental dwelling is located. Disorderly conduct that occurs outside of those areas does not count as a violation. Disorderly conduct is limited only to the following specific offenses. Go ahead and review the list. There are 24 enumerated offenses, and these are the only offenses that can qualify as disorderly conduct. The city has narrowed the list of offenses that may constitute disorderly conduct under the ordinance, and the list of what qualifies is specific. So disorderly conduct doesn't mean whatever might seem disorderly to you or a neighbor. It actually has to violate one of the listed offenses, and there may be exceptions that you might not think about. For example, under subsection 6, nuisance noise can be disorderly conduct, but the new ordinance explicitly accepts instances where the noise is caused by a medical emergency. And please note that the list often refers to Minnesota state laws. These specific references are important. Some conduct might seem similar to what's listed here, but only conduct serious enough to violate state law can qualify under this definition. So what happens if disorderly conduct occurs in a dwelling? If the Faribault Police Department determines that disorderly conduct has been committed on the licensed premises, the city will issue a notice. After the first instance, it will be sent to the licensee, instructing them to take steps to prevent further violations. The licensee must notify the tenant within 10 days. If a second instance occurs within a rolling 12-month time period, the second notice will be sent to the licensee, along with instructions for that licensee to submit a written report to the Faribault Police Department within 10 days, detailing all actions taken to respond to the previous notices. The licensee must again notify the tenant within 10 days. If a third instance occurs within a rolling 12-month period, the rental dwelling license for the licensed premises may be suspended, revoked, or not renewed by the city. Licensees must notify the tenant within 10 days of the notice and proceed with termination of the tenancy of all tenants occupying the unit. If the compliance official determines the licensee has proceeded in good faith to terminate the tenancy but was unsuccessful, the licensee may not be subject to penalties. Instead of revoking, suspending, or not renewing the license, the compliance official may require an action plan to be completed that outlines steps necessary to correct violations. Under the ordinance, both licensees and tenants have the right to an appeal. Both may submit information to the police department and seek reconsideration of the determination of a first or second instance of disorderly conduct within 5 days of being notified. Licensees and tenants may request a hearing to contest the determination from the police department that the tenant has committed 3 instances of disorderly conduct in a 12-month period, and that they can have the determination be reviewed by the City Council. At that hearing, all 3 determinations of disorderly conduct can be challenged. Licensees and tenants who are accused of violating the crime-free, drug-free lease addendum have the right to request a hearing before the City Council within 20 days of receiving notification of the termination of their tenancy. The hearing gives licensees and tenants the opportunity to challenge the determination and prevent the eviction. It's also important to note that state law and the ordinance includes provisions to ensure that housing providers cannot evict tenants or otherwise take any adverse action against them because they have sought police or emergency assistance against domestic abuse. The definition of domestic abuse includes the following when committed against a family or household member by another family or household member: physical harm, bodily injury or assault, the infliction of fear of imminent physical harm, bodily injury or assault, terroristic threats, criminal sexual conduct, or interference with an emergency call. Additionally, the ordinance says that tenants cannot be penalized for disorderly conduct where the tenant or tenant's household member or guest was a victim of the incident that forms the basis of the disorderly conduct. For purposes of determining a disorderly conduct event that triggers notice of a violation, the police department must evaluate whether the tenant is the alleged victim of the underlying disorderly conduct offense. If the tenant, household member, or guest is a victim, and the perpetrator is not a tenant, no notice of violation will be sent. Where the perpetrator is also a tenant, the police department will note the tenant's victim status when providing notice of a disorderly conduct event to a licensee. The licensee must note any determination of a tenant victim and must not take any action against the tenant victim or other household occupants who did not perpetrate the offense. Now we're going to shift gears a little bit and talk about occupancy standards, which is the number of people who can reside in a single rental dwelling. Occupancy standards that are overly restrictive can violate the Fair Housing Act because they discriminate against families with children. Additionally, occupancy standards that are more restrictive than the two options listed here can violate the city's rental ordinance as well. Please note that children under the age of 2 do not count towards the occupancy limit. For all members of the household ages 2 and up, the city requires that housing providers comply with one of these two occupancy standards. The first is the head count standard, which states that the number of occupants in the dwelling can be up to 2 times the number of legal bedrooms plus 1 person. So, for example, a household with 3 legal bedrooms can house up to 7 household members, not including household members under the age of 2. The other occupancy standard a housing provider may choose to use is the square footage standard, which states that each bedroom must be at least 70 square feet in size. If multiple people share a bedroom, the bedroom must provide at least 50 square feet per person. For example, if 4 people over the age of 2 share a bedroom, that bedroom must be at least 200 square feet in size. Just a reminder, children under the age of 2 do not count towards these totals. Lastly, I want to talk about penalties for a licensee who violates the city's rental ordinance. Penalties for violating any section of the ordinance include termination of the license. Additionally, violation of the ordinance is considered a misdemeanor, which can be punishable under state law. Finally, each day that a violation continues is deemed a separate, punishable offense. Thank you so much for attending this training today. For more information and for the documents discussed during this training, visit the Faribault Rental Inspections Program website. The web address is on this slide and is www.ci.faribault.mn.us/191/rental inspections program.